Hello and welcome to the Heart of It All, a podcast about navigating the realities of caregiving. Here's what we discovered last week. Sometimes those realities can be complicated. Estate planning is one of them. We are continuing last week's conversation about wills. This week, it's all about powers of attorney and powers of personal care with lawyer Jordana Talsky. Hey there, and welcome to the Heart of It All. And this is our part 2 with lawyer Jordana Talsky. So part 1 was all about wills and estate planning. And today we're going to cover the powers of attorney and powers of personal care. If you haven't listened to last week's, go back and do that either before you listen today or afterwards. It is also very important to have this documentation together for our loved ones so that when we do die, we do need to have our wills, our powers of attorney, and powers of personal care together. Our guest today, she's joining us again. Well, we cut it up in two, but I'm going to remind you who she is. Jordana Talsky was just named to the top 2025 Toronto's top lawyers list as nominated by her peers. Jordana draws on her broad experience from Bay Street and boutique firms to her roles as an estate and trust consultant for Scotiabank and independent practitioner to ease the complexities of succession planning and estate administration. Jordana was called to the Ontario Bar in 2010. She holds a law degree from the University of Western Ontario and a Bachelor of Arts in English Literature from McGill University. She has led estate planning workshops, spoken at nonprofits, and taught the estate law bar exam preparation course to international candidates. Jordana is also a performing musician, member of SOCAN, and I will say transparently, now my estate lawyer. Because I have some work to do, probably just like the rest of you. Jordana, let's start just like we did with wills. Let's start with that really kind of top level idea. What is a power of attorney?
Power of attorney is a legal document that gives legal authority to someone else to make various decisions for you, to be a substitute decision maker for you if you are incapable. There are some different types of powers of attorney, and also there's different terms in different provinces for what we in Ontario call a power of attorney for property and a power of attorney for personal care.
So, is your power of attorney part of your will, or is it a separate document?
Good question. It's a separate document. So your powers of attorney, and I'll just say powers of attorney to mean your power of attorney for property and your power of attorney for personal care, which we'll explain. They operate while you are alive, but let's just say you need someone else to help you, you're incapable. Whereas your will takes over after death. It only operates after your death. So they're separate documents, but they're often done at the same time.
Power of attorney and power of personal care. How are they different and how do they work in tandem?
Right. So they're both powers of attorney. One is called the power. I know the language is kind of strange. Power of attorney for property, power of attorney for personal care. So we'll just call it like POA is what we in the business call it. So POA for property and POA for personal care. POA for property grants legal authority to someone or more than one person to have a control over your assets. So that's for things like paying your bills and signing legal documents on your behalf. Some people also call it financial power of attorney, but the terms that we use in Ontario is power of attorney for property.
Okay. And give me an example of when, I don't know if I'm going to be using the right language here, but when you enact a power of attorney for property.
Great question. A power of attorney for property can be enacted at any point. Normally, people are preparing those documents while they're all with it. Yeah, because it's meant to function for you when you can't manage your own finances. It's meant to have like a stopgap, something to assist you during a period of incapacity. In order to be able to do that document, you need to have mental capacity, which is why we also often do it as part of our will planning process so that you have it ready to go. Now, you can make it so that it only operates if you've lost your capacity, but that can create some obstacles because that would mean that there'd have to be proof given that you've lost your capacity, and that can create some roadblocks. So, what we often are doing is something called a continuing power of attorney for property, which is signed when you have capacity, and it basically grants authority from this day and continuing on into your incapacity. But you keep that document safe because you may not want it acted upon now because you're fine, but you prepare the document with the intention that it could be used. That's for power of attorney for property, all the stuff we are just talking about.
Okay. Now let's talk about power of attorney for personal care.
So, okay, that's for granting authority to a substitute decision maker, one or more persons, to make decisions for you regarding your personal care. So, that could be medical decisions, it could be housing care, basically that personal care, hygiene, those kinds of decisions. And that only operates if you can't communicate with those personnel. So, you could sign it today and have it floating around, but as long as you're able to speak for yourself, it's fine. It doesn't mean someone can supersede and say, "Well, I have power of attorney, so I'm saying she wants this." No, if you can communicate, it's fine. That's the distinction between the power of attorney for personal care document and the power of attorney for property document, is that the latter is a more sensitive document that can become active and needs to be protected carefully. Power of attorney for personal care, no one's going to like tell someone, call up your doctor or whatever and say, like, do this. They'll call you and say, do you want this? Do you know what I mean? I'm just trying to outline.
So I asked you this about when we were talking last week about executors. Should your executor know that you've named them? I'm going to ask you the same question about power of attorney and power of personal care, or power of attorney for property and power of attorney for personal care. Look at me. I'm basically a lawyer, Jordana. Should people know that they have been named in that capacity in these documents?
Absolutely. Absolutely. Because they really need to know. They might be called upon to act. Absolutely. I think, and also I have had situations where someone was appointed and didn't want to act. And there's a way to resign and to not act, but it certainly creates problems for the person that then needs them. So I would highly encourage speaking with and getting permission even to name people in your documents. Hmm.
You have used the plural persons a couple of times. Is it advisable to have more than one power of attorney for property and power of attorney for personal care?
Yes, you can. And there's different ways that you can appoint people together. So you can appoint people to act jointly, which means they must act together in unison. You can also appoint them jointly and severally. That's a term, jointly and severally, which means that they're all appointed, they all have decision making power, but one can speak on behalf of the other. So they can be several, they can be on their own making the decision. And that provides a lot of flexibility. I often see multiple people named in powers of attorney for personal care because when it comes to medical decisions, carrying out someone's wishes for, let's say, end of life care, they often want to have a few balancing minds in the room. So sometimes you'll have all the children named jointly and severally or jointly. I see that often. And with property, it's a little bit more cumbersome because you may need attendance at a bank if you're appointing multiple people jointly, but you can also do jointly and severally. It really depends on the trust that you have in the individuals you're appointing.
It's interesting because we mentioned when we were talking about wills that you could have more than one executor, but it's not necessarily advisable or it can complicate things. Would the same thing apply here to powers of attorney for property and powers of attorney for personal care?
The short answer is yes, but I think there are valid reasons to have more than one person appointed in circumstances. I've just mentioned for personal care. I do think that there's value. It depends on the family dynamics. It depends on the trust level. It depends on a lot of different factors. Also, proximity. Maybe one child's moved away, but you really trust that child and you really think that they're going to know what you want. But then you got another child that's here. So maybe you name them both, like those kinds of situations. And for property, you know, on the one hand, it can be good for transparency for, let's just assume, there's 2 kids, for both kids to be on it. There's sort of less opportunity for questioning the actions of the other after the fact, but there has to be, again, trust and working together, and there is also opportunity for one person, if they have both have authority, one to do something untoward. So it's a kind of a tough answer. Sometimes depends on the family and the case by case scenario.
I'm gonna bring up, I'm gonna do a little callback to something you said when we were talking about wills and saying that, you don't want somebody as an executor who is in the US. If they're part of the Commonwealth, then that might be okay. Is that the same thing? Do we have to take into consideration the location of people when we're talking about naming powers?
Great questions. Yes, you do for the property, for assets, for financial, that one, the POA for finance and property. You need to appoint someone who's not a non resident. Yes, you do. You can appoint one person who is a non resident alongside someone who is.
So in my case, I have one brother and he lives in the UK. So we could both be powers of attorney for property and personal care for my mom if she chose. And I don't want to divulge what she said. It doesn't matter. I talk about my family all the time. I am the only power of attorney for personal care and property simply because I am physically here. That's the decision kind of we made as a family.
And it's a practical decision. It's not a wrong decision. Yeah,
Okay.
I do think it creates some added complexity when the person's not here, but it really is like preference of the individual.
Okay, so knowing that what we're talking about here is estate planning, Jordana. We've covered wills. Now we're talking about powers of attorney for personal care and powers of attorney for property. We have an executor in our will. Should our powers also be our executor? Should all these people be one person or the same group of people?
Also a good question. It's not necessary. The only advantage I could see is that if someone's acting as your attorney for property, they will have to assume like custody of your assets. They'll be managing your finances. They're going to know the picture leading into then when you die. If they're the executor, they're going to know where things are. They're going to already have the authority to be doing certain things in their role as an attorney, but that could help them through into transitioning it to an estate. So there are some advantages. Personal care, I don't think so. I mean, they need to be communicating with one another. That's something else to take into account is the person who's appointed as the attorney for property and the person who's appointed as attorney for personal care, assuming there's one each, should be communicating with each other because let's say the one for personal care needs to make a decision about home care, okay, but needs funds for that. They're going to have to go to the attorney for property. So you want to think about who's doing what. Maybe it's the same person if there's a lot of trust there. Maybe it's different, but can they work together? And then, yeah, the added piece of would it make sense for the attorney for property to also be the executor? Sometimes yes, sometimes no.
Interesting practical example though there of somebody is in a situation where they need more care. That is a decision that your power of attorney for personal care would make, but needs access to funds, which is under the jurisdiction of power of attorney for property.
Hmm. Yes.
Great, great distinction there. But again, in the interest of clarity, when you make your will, is powers of attorney for both things, is that always part of the will experience?
Not always, but it's always encouraged. I always ask clients if they're coming to me for a will, do you have powers of attorney? And if they don't, I encourage them to prepare it because they're fairly straightforward, non complex documents that wouldn't take a huge amount of time to draft. So it makes sense to do them. And if they do have existing documents, I'll usually ask to review them if they would like a review and maybe update them. Yeah, it should be, I think, a part of the will process.
If you are a person who is interested in having the least complicated, is the least complicated decision to have one person be your executor and your powers of attorney for property and power of attorney for personal care?
Yeah. Yeah.
Yeah.
It's a lot for that person to handle. That's a lot. And
So am I hearing you, Jordana, that you would recommend having more than one person in those three different roles?
No, not necessarily. Because sometimes it just does make sense to have the one person be. I don't know, it's my spouse. My spouse knows me the best. They're going to come with me to the hospital. They're going to be paying my bills and they're going to distribute money to my benefit. Yeah, like that's best case scenario. If you can have a life where that is, nice and neat and tidy, yeah, great. And the person can handle all those jobs, great.
So, Jordana, what if people are in a situation they don't really have anybody to name as an executor?
Life's complicated and relationships are complicated, and oftentimes there aren't people in place, which is why we have trust companies. So I just wanted to touch on that. I used to work for a trust company. So most main financial institutions will have an arm of their institution that is a trust company, and they act as executors and as attorneys for property for individuals who either don't have anyone to appoint or just want to have an independent, neutral party, which can be a huge benefit and weight off of people's shoulders. And if there's any potential acrimony, it just takes the characters out of it. It's a separate party. It's a great option if possible.
Is living will and power of attorney for personal care, are those kind of interchangeable terms, Jordana?
The proper term in Ontario is power of attorney for personal care, but we include what we refer to as living will language in that document. Living will language are sort of an expression of wishes for certain kinds of care, which you may find this in other documents in other jurisdictions, and also you may find it in something called an advanced healthcare directive in Ontario, which is a complement to the power of attorney for personal care. So just the distinction is the power of attorney for personal care gives legal authority to a substitute decision maker, and then they have to carry out your wishes. So sometimes we will put some of those wishes. It's not a must instruction. It's just an indication for the person who's being appointed as to what your wishes are. And that's the living will language.
We're going to have Dr. Jean Memorio on the podcast in a few weeks talking about MAID. And I'm wondering, is that some of the language that would be dealt with in our power of attorney for personal care or our living will language?
I include a statement regarding what we call heroic measures or no heroic measures, that if there is um, no reasonable expectation of recovery from an injury or illness, does the person want artificial nutrition and resuscitation, etc., and prolonged measures to sustain their life? We have language around that. With regard to MAID, it's not at this time possible to give authority to a substitute decision maker to engage in MAID for you. That might be changing, so we don't include that. But I have prepared some documentation around wishes, which it's not like legal or valid yet, but it's wishes, and there's nothing wrong with that, so that someone knows what you'd like.
Yeah. And I mean, speaking from somebody who I thought I was really quite clear on what my dad wanted and maybe more importantly didn't want when he died. But when he actually died, it's a very difficult time. And I think it's the more detail that you can leave for your loved ones in all of these documents, whether it be wishes, whether it be specific directives for funeral, celebration of life, the things that you really want to have happen. What a gift. What a gift.
Fully agree. Yes. Having experienced it yes, I do agree.
So you brought up spouse because that maybe is the most obvious situation that one person would sit in all three roles. But if you have a spouse, is it always the spouse?
No, it's whoever you want. There's no rule about who it has to be, subject to, you shouldn't appoint someone who's a non-resident. But no, no. And they have to be of age of majority. And other than that, you can do what you want.
Okay, so what about dealing with multiple children? Should each of these roles, executive power of attorney and power of personal care, if you divided them up equally, if you had a different child in each role, I recognize that we are talking about family dynamics, but you are a lawyer. I'm wondering from just the legal perspective, does it matter?
No, it
So
doesn't.
all of these considerations, Jordana, when you're making these directives, when you're creating these documents, is really taking into consideration the people that are in your life.
Absolutely. People seem to think, I think I've mentioned this earlier, that they should appoint somebody or that they must include this person or that person just because they think it would be proper. And that just isn't the case. You really need to think about who those people are because the job is the job. And it's not so much about how you feel about them as people. I mean, that plays into it, but it's also, can they do this job for me?
Can they do this job for me? It's a big question. It's a big job, really. I'm so glad that we're pulling back the curtain on a lot of these things that people think they know about and people have no idea.
Yes. Yes.
They really don't. I mean, I'm guilty of it. I thought I knew a lot. Okay, another scenario that I think is really commonplace. And I'll tell you a story. When I first started doing this podcast, I have a friend who's child free, has some family, but isn't particularly close with nieces or nephews. And she said, can you do an episode on what I should do for my estate because I don't have family to put in these roles? And I think there's a lot of single people or people who are married without children. What conversations do you have, Jordana? And where can people even start to think about who are the appropriate people to put in these very important roles?
Well, so there's a few questions there. So, in terms of who to appoint, to act, let's say, as an executor or an attorney, that kind of a circumstance, there'd be a good candidate for a trust company or an independent person like a lawyer, a law firm, or other professionals. There are professional executors and professional attorneys for property, and even professional power of attorney for personal care. Not a lot, but there are these people who, for a fee, will perform this job. And I've I have experience with trust companies. I used to work at one, and I can say that they're excellent. They're very skilled at what they do. This is what they do. They know how to do it. So it really is just a question of, I think, the fees and are you okay with having someone independent involved in your affairs? That's the question on like who. And then what, what to do with your estate if you don't have family or other close people to leave to. Often it's a discussion about like other charitable aims. Do you have charitable aims? Would you like to leave to a few charities or perhaps set up a foundation or donor advised funds? Lots of ways to give. Yeah, because we do need in our will to say something. I can't leave it blank. You can, I mean, now we're getting into nuance. You can give authority to the executor to make decisions, but they need to make decisions. So, yeah, you need to have those conversations. I mean, it could be a good opportunity for someone to get involved in community to sort of scope out if there are aims they'd like to benefit.
And it is something that I think for people who don't have children, um, to really think about. And as much as people might say, I don't have anything, as we covered in the conversation about wills last week, everybody has something, even if it's just your bank account. Things need to take place once you die.
Can't avoid it.
Can't avoid it. I do say to people all the time, like, this podcast, uh, came about because after my dad died, I realized just how we're just doing a terrible job in society of talking about things and having transparency and helping seniors live great, great lives because people are living into their 90s and having the best time ever. It's great. It's wonderful. But we do need to have these communications. We do need to talk about these things. And the only thing that is guaranteed is that we are all going to die.
It still is really taboo, and, yeah, I mean, I'd like to help, uh, dispel. I don't really know what I hope to do in being able to share education about it to open up that conversation. You know, it is a weighty issue, and I think people really do feel a sense of relief once they've done it, so I would suggest to people that by just doing it, you may feel better about the whole thing.
I agree. I feel really good about these 2 episodes of this podcast. I feel like we've talked about so much. I have some actionables from you, and I do think there is nobody who is over the age of, I don't know, fill in the blank. I'm gonna randomly say 45 or 50 that hasn't gone, "Yee, I should do a will." And it's occupying this part of our brain, and just imagine getting that part of your brain back.
Yeah. Got better things to do.
That's right. I just want to drill down a little bit more into this idea of if you don't feel you have anybody, if you feel you want this to be a person who's not going to be emotionally involved at all, what are your options?
Your options are a professional trustee, and that could be a lawyer, or sometimes accountants do it, or a trust company. And they are institutions that are designed to handle these tasks. They're very skilled, they know what they're doing. There's a fee for services. So that's usually the biggest roadblock in people's minds. I don't want to pay for this, or I don't want to take money away from beneficiaries. And to them, I would say that's a fair point, but often you end up spending more if you appoint a layperson or family member that is not equipped and then has to spend time and money figuring it out. Yeah, I would say that it's a great gift to the estate, if the estate can afford it, is to have an independent person acting. It also avoids certain problems, acrimony in certain relationships. When there's an independent, neutral third party, can really help manage those situations effectively.
Right. So maybe if you don't have anybody, or maybe if you already know that the people that you have could be problematic, this is another opportunity for you to avoid some of that acrimony. Last episode, we talked about wills. This episode, we talked about powers of attorney for property and powers of attorney for personal care. All 3 weighted equally in your mind in terms of importance of estate planning?
Yeah, all important, because powers of attorney operate while you're alive. You need help while you're alive sometimes, and they do very distinct things. And then the will operates after death, does a whole other thing, still need it. So, yeah, all 3 important.
I loved what you reminded us about last episode of where to keep our wills and do not keep it in a safety deposit box. I'm remembering that forever. Do we keep our documentation for our powers with our will?
I would. And you could also give usually for the power of attorney for personal care, there could be multiple original copies of that, because as I mentioned, it's less of a sensitive document, because as long as you can communicate with whoever, they're not going to look to the other person. So for that reason, we will sometimes prepare multiple originals, and you could give that original to the person you've appointed so that they have their own copy that can be used if needed. And in the case of the power of attorney for property, yeah, keeping that with the will, or in certain trust scenarios, maybe you give it to the person who's named, but that really depends. I would say just maybe have your own safe place where you keep those documents.
Thank you so much. I've learned so much. I know the listeners have learned so much, and I'm sure I will have more questions. Now that I've got your email, you're really in trouble.
No, I feel like there's also so much more we could discuss. So please feel free, send me those questions. And if the listeners, anyone wants to reach out, please feel welcome.
We are going to have all of Jordana's information in the show notes, and you can always reach out, DM me, whatever, if you need, if you're having a problem with the show notes. Jordana, thank you so, so much. I cannot tell you how helpful all of this is.
My pleasure. It's great to chat with you. Thank you.
Thanks so much for listening to this episode of The Heart of It All. I loved all of that information. Of course, this is a podcast about navigating the realities of caregiving, and our death is part of that. We'd love to hear from you. Do you and your family members have wills? What concerns you about estate planning? How transparent is your family about what your end-of-life wishes are? Follow us on Instagram, Facebook, TikTok, and YouTube at The Heart of It All Pod. If you like the podcast, please subscribe and share this episode with someone who you think could benefit from these conversations. Also, consider giving us a review on Apple Podcasts, Spotify, or wherever you get your podcasts. The podcast was created, executive produced, and is hosted by me, Teri Hart. I couldn't do it without my co-executive producers, Carrie Hayden and Jess Carroll of 6 of 1 Digital. Music is provided by Riverside. Thanks so much for tuning in, whatever time of day it is for you, and please always take care. So estate planning was such a big topic. We split it into 2 episodes. Last week was all about wills. This week, powers of attorney for property and powers of attorney for personal care. And last week I chose The Descendants from Alexander Payne. And this week I'm going into the TV world and an epic show about all the decisions that you make about what happens in your family, in your business when you're no longer here. Succession. Have you watched it? I'm telling you, you could rewatch it. If you don't like swearing, put earmuffs on because, oh my goodness, there's so much swearing, but truly an excellent, excellent show.